All right, can you hear me now? All right, good
Sure
morning, everyone.
can.
Had a bit of trouble there with my microphone. It kept going back on mute. Look, welcome to today's webinar. My name is David Huxley from icare's mobile engagement team, coming to you from the far north coast of New South Wales, where I live. But I'm on Bundjalung country. I want to pay my respects to elders, people and ancestors of this beautiful country where I'm based. Also want to pay my respects to the traditional custodians on the various lands which we all work today. I just want to start off with a little bit of housekeeping. Everyone's camera and microphone are disabled now, so there should be no interruptions. We're going to close off that chat box. It's just been closed off now, I see, to minimize interruptions during the main part of the session. And we will reopen this chat box at the end of the session for feedback and for questions. Look, with regards to questions, we have over 1,000 registrations for this webinar, and we can't answer everyone's questions. So what we've done, we've included as many answers to questions raised through the registration process in the presentation, but right at the end, we'll endeavour to, get to any questions that people can pop in the chat when we open that back up for those that want to hang around after the formal part for the presentation. The final bit of housekeeping is the session is being recorded today and will be made available on our webpage in about, I'd say, 2 to 3 weeks' time. Now, today's webinar is the first of two during which we are partnering with Turks Legal to provide some clarity around a couple more complicated topics in the workers' compensation scheme in New South Wales. In this session today, we're discussing the difference between a worker, a deemed worker, and a contractor, and how they are treated in the New South Wales scheme. In about 4 weeks' time, late August, we're going to be covering off on what you need to know about cross-border workers and any staff that may be working interstate. We're going to provide you with the details on how to register for that session at the end of today's webinar. Look, on that note, it's time to introduce my special guests here and our subject matter experts. We have both Sean Patterson and Shiraz Basevic from Turks Legal. Thanks for joining me today, gents. How are you both feeling today?
Thanks, David. We're great. Thank you. Thank you for having us here. Just a bit of an introduction to myself. Sean Patterson here. I'm a partner at Turks Legal. I've been working in this space for about 8 years now, solely on the respondent side of things. So on behalf of insurers who look after employers around New South Wales.
And my name's Shiraz. I've been with Turks for 4 years now. Before that, I was a legal specialist at an insurer. So I've been on both sides of the fence, as it were.
We found it easier to have Shiraz on our side than as a client, so we brought him over.
Fair enough. Tough customer, Shiraz is, that's for sure. Look, guys, I'll be controlling the slides today, so make sure you give me a prompt if I need to sort of change the slides and move forward. But look, I just thought, to set the scene here, I might just start off on a quick example of my own, from my own experience. So from about 10 years ago, or a few years ago now, when we built the house that I'm currently in right now, and it's a pretty common example for many employers, especially those in construction who may be a little confused about, who they should be covering through their workers' compensation policy. Now, the builder I engaged was a small house builder, local small house builder, who we'll just call Bob the Builder, just for this example. And he had 3 carpenters which worked for him directly. These carpenters, or chippies as they're known, would invoice Bob at the end of the week for the hours worked. And their invoice would include their ABN number. They also went from job to job with Bob as he picked up new building contracts. Now, one day Bob approached me and asked me about his workers' comp policy, knowing what I do for work. He wanted to make sure he was doing the right thing. So what he told me was his carpenters, they're all sole traders, they each have an ABN number, and they sorted out all their own insurances and taxes, that type of thing. And Bob thought that he didn't need to cover them on his workers' compensation policy. But after discussing this with Bob and getting a bit more detail about the contract and the employment status, it certainly sounded like that would be a deemed worker of Bob, and he should probably be including them on his workers' comp policy. Now, Bob wasn't too keen on that idea, so what he did was, talk to his chippies about forming individual proprietary limited companies, and then each company would contract to Bob's business as the principal contract, as Bob's business would be the principal contractor moving forward. Now the chippies, they did agree to this, and they each formed a company, meaning that now it would now be working directors of these newly formed proprietary limited companies. The issue remained, however, that no new separate workers' comp policies were taken out for each of these newly formed companies, meaning that they were uninsured. And even more important to note, as they were working or contracted to Bob, if they injured themselves on Bob's job site, that would most likely fall under Bob's policy. And even be liable for unpaid premiums for these uninsured companies. So this is why it's so important to understand the difference between a worker, a deemed worker, and a true contractor, and why we're sort of holding this session here today. So we'll get into it now, guys, and I'll just flick over the first slide. Now today we're looking at the definition of a worker, deemed workers, and to provide you with information that you will need to obtain to assist to help you understand the status of your workers. We'll also be sharing some real court-tested case studies to help support your understanding along the way. So Sean, why don't you define exactly who is a worker under the legislation and what might constitute a contract of employment, as this might not always be as straightforward as it sometimes seems.
Absolutely. Okay, so the definition of a worker for the purposes of workers' compensation is dealt with in Section 4 of the 1998 Act. It's up there on the slide. So a worker means a person who has entered into or works under a contract of service or a training contract with an employer, whether by way of manual labour, clerical work or otherwise, and whether the contract is express or implied, and whether the contract is oral or in writing. We'll get to some cases where there is a contract that's in writing, and other instances where there's perhaps not a contract, or it's not clear whether there actually was a contract of service. The elements of a contract of employment. So there's 4 key pillars to that, and that's offer, so an offer to do some work, acceptance on the part of the claimant to do that work, actual performance of that work, whatever it may be, and consideration, which is, payment of wages or some other form of remuneration. Next slide there, David. So as I briefly touched on the previous slide, a contract of employment can be formal and in writing. So that's your classic employment contract. So that's one between you and your employer. I would have a contract of employment with Turks Legal, as would Shiraz. Informal and verbal, so it could be nothing more than a phone call, a discussion you've had with a particular claimant about coming to work on a site perhaps, or anything between. Often we see that there's, conversation and text messages exchanged that give the bare bones of what might look like a contract of employment. So a contract of
Sorry, mate. You go.
Go on.
No, I was waiting. You go.
So a contract of service, that would constitute employment, and that'd be a worker. And then a contract for service would be an independent contractor or principal.
So if we go to the next slide, Dave. So obviously as lawyers, we look for the evidence of these kind of relationships. And here we've got just set out what you can look for to see whether someone's a principal or a contractor, or an employer-employee relationship. And we've got the evidence that you'd need on the side. So the method of payment is obviously key. If you're a contractor, generally they set the rate of pay and they invoice for that. They have an ABN, as Dave has said, but that in itself would not be determinative. They might operate under their own business name and pay their own business expenses, including tax and things like that. Whereas if you've got an employer-employee relationship, I mean, I'd love to set my rate of pay, but generally the employer sets the rate and you accept that. In return, they deduct your income tax, they pay your super, and they give you things like sick and annual leave in return. When we look at tools, generally speaking, we're looking at more sort of skilled labor roles. A contractor would generally supply their own tools and equipment, whereas an employee, it would generally be provided for them. When we're looking at contractors as well, generally those are skilled professions to a lesser or greater extent, which would be important. But really the control or the right of control, that used to be one of the fundamental tests for whether someone was a contractor or an employee. In essence, if an employer has a right of control, they tell you when and where and how to do a job. Generally, they weren't considered your employer alone. Whereas now, if we're sort of looking at the contractor relationship, they would generally, I mean, if you hire a contractor, they will generally tell you, look, I'll be there at 2 o'clock. You know, you don't really tell a contractor how to do their job. You kind of, take for granted that they know how to do it and they'll perform it to the best of their ability. Presentation is also sometimes important. Are they wearing your uniform? Are they generating goodwill for your business or doing it for their own entity? Delegation is really important, not just to sort of employment contracts, but when we look at deemed workers, that's a particularly key point. Does the person doing the job, do they have the right to delegate that to other people? I certainly don't have the right to delegate my job to anyone here. I have to do it on my own, so I'm very firmly an employee. And exclusivity and obligation to work. Does this person work under their own business? Can they accept or turn down work from other employers? Is it an exclusive working relationship? And obviously your right to dismiss, that's a pretty simple one to look at.
I'll just add there as well. In terms of the evidence you need, I think these slides are going to be circulated post this session. But if a factual investigator, which is generally the case, comes knocking, if there's a contentious claim where you're not sure whether a claimant, is a worker or deemed worker, that evidence you need is a good place to start in terms of documents to produce to that factual investigator. So obviously any contract, but then invoices, pay slips, bank statements, statement evidence that you can provide documenting the nature of the relationship you had with the claimants, and emails and text messages as we've also flagged. So in terms of who is the worker, the questions to ask and evidence to obtain, so I just touched on that then. But there's some recent High Court decisions as well, which I'll get into one of them shortly. But the first question to ask yourself is the claimant conducting his or her own business, which would suggest a contractor, or are they serving the business of the employer, which would suggest a worker? The contract is important. So what was agreed and what was the intention of the parties? When there's no comprehensive written contract, which we'll get into in a second, we'll go to the multifactorial approach, which Shiraz just detailed in that previous slide with the table. And it's important to note that the onus is on the claimant to show that the contract relied on is one of employment. So as with most things, the claimant's got to prove that, or they got to prove their claim, so to speak, and that there was one of employment.
Right. And as you referenced, we're covering lots of material, including that really important table we just shared, and we will be sharing. There'll be an email that goes out, guys, probably the next day or so, with a copy of all the slides that we're talking to today, as well as some other important reference material, which can support employers in understanding the status of their workers. But we might move on to the first case study, Shiraz. And look, we have lots of people joining us from construction industries who want to understand some of these concepts about potential workers versus contractors. And we have the case study of Terry the tiler. So why don't you explain just what happened to Terry, and then we can look at his employment status.
Yeah, definitely. So first things first, as far as I understand, this is not a real case. It's just an example. But Terry is an experienced tiler, and he injured his back when he slipped on a wet tile in January of 22. He'd started working for the insured A1 Tiling 6 months earlier, and he was earning about $400 per day. And he worked often on the weekends, as well as all of the weekdays. So if we're looking at the facts on the next slide, as we said, Terry is an experienced tiler. Jack is the director of A1 Tiling, and Terry advertised his services on Facebook and by word of mouth on that and other job sites. Jack heard that he was looking for work and he offered to pay him $400 per day. And Terry performed tiling work for him on various job sites over about a 6-month period. Sometimes Jack would contact Terry, other times Terry would call Jack looking for work, and that's basically the nature of their relationship. Jack gave him a shirt to wear with A1 Tiling's logo, but Terry never wore it. There was no real expectation to do so. Terry, being an experienced tiler, he supplied his own tools and PPE, but he did have to ask Jack before he accepted work from other people he met on job sites, which is not uncommon. Terry invoiced Jack for work performed. He supplied his ABN, and the amount that he charged included GST. He could work for others, and the invoices that he supplied to Jack did show gaps between jobs, but the invoices were sequential. And this one's really important down the track. Terry could engage a labourer to assist him, and when he did, he paid them out of his kind of contracted rate, which was $400 per day. He wasn't paid any sick or annual leave entitlements or superannuation, and Terry set the hours of work and he wasn't supervised. So there was not that sort of element of control. So in looking at whether he was a worker, there are some things to suggest that he was, there are some things to suggest that he wasn't. The provision of a uniform, even though it wasn't worn, generally is a contract of service, so indicative of him being a worker. And the agreement that he would ask Jack before taking on work from others. That's, again, more of a worker relationship. But on the other side there, we've got all the things that suggest that he's a contractor. That includes the fact he was submitting invoices under his own ABN. He could engage others to work, and he was responsible for paying them. He wasn't paid your usual sick and annual leave entitlements. He advertised his business himself, and he generated goodwill for that business. And he charged Jack a daily rate rather than an hourly rate. He performed sporadic short-term contracts with A1 Tiling, rather a consistent sort of working arrangement. So if we look at the totality of that, most of the evidence would point to Terry being an independent contractor. The vibe, which a lot of this ultimately comes down to, is that he was more conducting his own business rather than serving Jack's business. The little that we do know about their agreement is consistent with this, that he was working essentially for his own business. So in this case, it would lean more towards him being an independent contractor rather than a worker. But we'll get into it a little bit later when we get to deemed workers as well. Okay.
So Terry the Tiler is a classic example where there's no written contract per se, but we've got the High Court decision here of Construction, Forestry, Maritime, Mining and Energy Union and Personnel Contracting, a 2022 decision. So in this case, the claimant was a backpacker in Australia on a working visa, and he signed with the labour hire company, in which he described himself as a self-employed contractor. So that was the official title. But he was allocated to work on construction sites run by a host builder. He was assigned tasks by the host employer, but there was no contract per se between them, given that he was part of a labour hire company. And after his engagement ended, through the union, he commenced fair work proceedings, seeking compensation and penalties for alleged breaches of the Fair Work Act. The claimant obviously contended that he was an employee of the labour hire company and not a contractor, despite what the title of the contract might have suggested. The federal court at first instance found that he was a contractor, but then it proceeded to appeal to the High Court. In that instance, he successfully established that he was in fact an employee. The court concluded the multifactorial approach was not necessarily where the parties' rights and obligations were entirely contained within a written contract. So in this instance, given that there was a written contract, it was in fact more persuasive than what the multifactorial approach would be that we touched on before, which is kind of like a fallback approach in the absence of a contract, which might apply in Terry's case. It was noted that the labour hire company determined the rate of pay and paid the claimant directly, retained a right of control over the claimant, and could terminate the claimant's employment whenever they wished. What was considered irrelevant was the label of the relationship. So the court looked at the substance of the relationship rather than the form of the contract where he was described as a contractor. I've got a quick quote from the decision itself from the High Court. Where the parties have comprehensively committed the terms of their relationship to a written contract, the validity of which is not in dispute, the characterization of their employment is one of employment or otherwise proceeds by reference to the rights and obligations of the party under that contract. Where no party seeks to challenge the efficacy of the contract as the charter of the party's rights and duties on the basis it was either sham or otherwise ineffective under the general law or statute, there is no occasion to seek to determine the character of the party's relationship by the wide-ranging review of the entire history of the party's dealings. Such a review is neither necessary nor appropriate because the task of the court is to enforce the party's rights and obligations, not to form a view as to the fair adjustment of the party's rights might require. So it's important to note there that they will look at sham or otherwise ineffective contracts. So when everything's set up in a particular way to suggest that they might be a contractor, going back to Hux's example at the start, they'll actually look at the form of the contract rather than just, I suppose, the title of the contract. It was also relevant in this matter if the claimant was free to work for another company, as that's a common feature of a casual employment, and he wasn't actually in this instance. And there was a similar approach applied in terms of the principles, but a different outcome in the case listed below on the final point of that slide down there.
Jamsec there.
Which was handed down on the same day by the High Court.
So the main takeaway with this one is when we're looking at workers or an employee relationship rather than deemed workers, if the contract is comprehensive and it features all of the parties' rights and responsibilities, generally it'll be considered determinative, provided it's not a sham contract. It doesn't affect the deeming provisions, but they'll generally look at the contract and the substance of the contract rather than any sort of titles that might be given there. So the contract may say is an independent contractor, but all of the sort of employees' rights and responsibilities are listed there. It does seem to suggest that, someone will be considered an employee or a worker. Okay.
Well, on that note, sometimes, as you're saying, an independent worker may at times be a deemed worker, depending on those circumstances. So, Shiraz, why don't you take us through when this may apply and cover off on a couple of examples for us?
Yeah, definitely. So look, deemed workers, as I'm sure most of us would be aware, it's kind of a catch-all provision for people that are engaged in contracts to provide work, but aren't considered workers. It provides them sort of the same rights under the workers' comp legislation. What deemed worker is, it's set out in Schedule 1, again, of the 1998 Act. And there are 4 key things that are looked at. That they are a party to a contract to perform work. Again, how that sort of contract is set out, be it through text messages, a verbal contract, or a written one, is not really relevant. Was there a contract to perform work is key. That the work exceeds $10 in value. Generally speaking, that's not a difficult one to overcome. The third one, that the work is not incidental to a trade or business that they regularly carry on in their own name or under their own business or firm name, and that they don't sublet the contract or employ others in the performance of that contract. So generally speaking, 1, 2, and 4, those points are pretty easy to determine. Number 3 can be a bit of a tricky one to look at. Do they have their own independent trade or business? Do they hold themselves out to be carrying on that trade or business? And is the contract between the claimant and our insured within the scope of that claimant's usual trade or business? So if the answer to one of the above is no, then point 3 is satisfied. Conversely, if the answer to them all is yes, then it's not. So if we go on to the next slide there, Dave. So again, questions to ask and the evidence to obtain for a party to a contract to perform work. If there is no contract, they won't be a deemed worker. Again, the evidence is pretty similar to that we look at for whether a person is a worker. You're looking at the contract, the invoices, statements, bank statements, pay-as-you-go summaries if you have them, as well as the individual person's tax returns, just to determine, are they working for others? Are they carrying on a trade in their own name? Does the work exceed $10 in value? If it doesn't, they're not going to be a deemed worker. It's important to say $10 in value. It doesn't necessarily have to be $10 or more. Do they have an independent trade or business? And if the answer to that is no, then they're not going to be a deemed worker. Do they hold themselves out to the public as carrying out a trade or business? Again, if the answer to that is no, then they're not going to be a deemed worker. Do they sublet the work or employ someone else in performing it? That is usually key. And is the contract within the scope of their usual trade or business? Again, the slides will be circulated, but the evidence that we're looking at and the important things to kind of keep in mind or to retain your contracts, statement evidence if a factual investigator asks to speak with you, but also things like invoices that are provided by the person that's claiming to be a deemed worker and things like that.
Yep. So not carrying on trade in their own name or business is always a contentious point when it comes to deemed workers. We got Wathen and AUT Holdings, an old case there now on the slide. A contractor who had given up his independent business for a limited time to work solely for a particular principal was found to be a deemed worker in that case. So in essence, he ceased working as an independent or in his independent business to focus solely on working for what turned out to be his deemed employer. So he was found to be a deemed worker entitled to compensation. Another case there relied upon by Deputy President or the now late Deputy President Roach. The claimant previously had his own trade and business, but he was nonetheless found to be a deemed worker because at the time of the injury, he was working exclusively for the respondent, and he was for some time as well. He didn't advertise his services to the public, so he didn't have, advertisements up on Facebook or Seek or anything like that. He was working exclusively for the respondent. And he was entitled, it's important to note here, that he was entitled to the benefit of the deemed worker provisions despite using his own tools. No income tax was deducted from his payments and invoices were submitted. So while they could be persuasive, they're not necessarily illustrative of whether a worker is whether a claimant, is a deemed worker. In this instance, he was working exclusively for the respondent, had been for some time. So the nature of the business relationship was such that he was a deemed worker.
Yeah, so if we go on to the next slide, Dave, in Payne and absolute domestic cleaning, this is a classic case that kind of illustrates that point. In this one, the claimant suffered an injury to her right leg when she fell down a flight of steps. She had a contract with the respondent, and the respondent contended that she was an independent contractor, which is not uncommon. She was required to have her own ABN and a police check. She didn't ask why. She just did it. And she did have to work a minimum of 10 hours per week and submit payment summaries by 5 p.m. every week in order to get paid. She did have to give notice for resignation, and she was also provided a uniform. In this matter, Member Burge, he noted the decisions that Sean spoke to, the High Court decisions in Personnel and JAMSEC, but he noted that they relate to contracts of employment and they don't affect the deeming provisions. The deeming provisions are kind of a catch-all for people who are very uncontroversially not workers. And we've got a quote here from Emma Burge. He said, it should be noted that even if the applicant had carried out work for someone else, that doesn't necessarily preclude her from being either a worker or deemed worker of the respondent. In terms of the deeming provisions, they relate to the nature of the relationship between the parties, which is really important. So the relationship between the parties at the time of injury is key. In any event, as the High Court noted in Personnel, it is commonplace that casual employees do not work exclusively for one employer, unless it could be shown that any other work was regularly carried out by the applicant in her own name or connected with a business of her own. She could still be considered a deemed worker of the respondent. However, that was a moot point. And this one, as evidence clearly established that she only worked for the respondent from 2018 until the date of her injury. So the relationship between the parties at the time of the injuries is key. If there's an exclusive working relationship, or in the alternative, if it's the work that they're performing is not something that they carry out for themselves under their own business name, they are more than likely going to be a deemed worker. Okay. So if we go on to the next slide.
So we've got a case here where it was actually found that a claimant was not a deemed worker. So it's Ali Al Anzi and Skyview Formwork Pty Limited. In this instance, the claimant was a labourer on a building site, and he had contacted one of the respondent's directors seeking some work. So basically, just made a call and asked for a bit of work. The respondent's director confirmed he was starting a new job soon, but the claimant would need his own ABN. The respondent needed 2 workers, and the claimant said he had another bloke available. A rate of $650 per day was agreed to cover the claimant and another person he had organised. The claimant performed the labouring work and invoiced the respondent through his ABN, and the claimant provided his own tools. Invoices confirmed to regular working days, no tax was deducted, there was no leave allowances, and he wasn't paid any superannuation by the respondent. The claimant sustained injuries when a beam he was working on collapsed and he fell 3 metres to the ground. Liability was obviously disputed on the basis the claimant was not a worker or deemed worker. In this instance, obviously, there's no written contract, so the member was left to consider the multifactorial test. He considered conversations in March and April 2020, and they reviewed them to assess the contractual terms established, and found that the claimant had not established that a contract of employment had been created. He said, and I'll just quickly quote here, indicia in favour of a contract for service is the evidence of Mr. Gurgis of what was said by him in the March conversation and provision by the applicant of an ABN, the mode of remuneration. There was no regular pattern of days worked, no tax was deducted, no superannuation was paid, and no paid leave was provided to the applicant. Based on the totality of evidence, including contractual terms, the subsequent conduct of the parties, and the application of the multifactorial test, I'm not satisfied the applicant entered into a contract of service with the respondent, so he was not a worker under Section 4 of the 1998 Act. The member gave some consideration to deemed worker, but the respondent essentially contended that the claimant alleged anyway that he was a full-time employee. So they argued anyway that he should be precluded from relying on the deemed worker provisions, as this was inconsistent with his primary position, which was that he was a full-time employee, so that he was a worker. The member accepted the submission and found the claimant was not a deemed worker. So it's important to take note of the fact that a worker can't necessarily have their cake and eat it too. They can't say that they're on the one hand a worker or in the alternative a deemed worker, because they're entirely inconsistent positions that could be adopted. So in this instance, the member said, yep, no, I agree, he's not a deemed worker, and it would be, I suppose, wrong to make a finding then that it's a deemed worker when that wasn't his primary submission.
Well, let's move on to the next case study, Shiraz, as it appears that the business arrangement in this example is like many famous business deals. It was arranged over a schooner of beer at the local pub.
That's right. So we've got Shane and Michael here. Shane was regularly down at his local pub and he drank there. And he was injured when he fell off a ladder painting a large window frame at the pub, as one does. If we look at the relationship between the two, over the 6 months or so before he was injured, Shane had done some little sort of bits and pieces, odd jobs for the then licensee Michael at the pub, presumably to make it a better place for him to drink. He was paid cash and reimbursed for any material that he supplied, and all up he just did a few hours of work. Besides that, he hadn't worked in a couple of years and he was on Centrelink. And about a week before he was injured, Michael introduced him to the new licensee, James. Shane told James, look, I've previously done painting work here, happy to keep doing that whenever you need. And James asked him to paint a large window frame at the pub. Shane had his own tools. He said he'd buy what else he needed, and James could pay him back. And they agreed on a rate of $25 per hour, with the work to be conducted a few days later. At some stage, the men discussed the job. James suggested cheating over the glass. Shane disagreed. Obviously, he's the pro here. And there was no other discussion about how or when the work would be done. Shane was essentially left to his own devices. On the day that he was injured, he went down to Bunnings. He bought what he needed, and he then borrowed a ladder from the bottle shop. He was working on the window, the ladder shifted, he fell off and sustained the injury. So not an uncommon occurrence or kind of arrangement. He was unsupervised, he was working alone. He obviously hadn't asked anyone else to help him. And after the injury, his flatmate went to the pub and collected what he was owed in terms of the work that he'd actually done. So Shane is not a worker. There is not an employment contract, but is he a deemed worker? So what we look at is there was obviously a contract. There was an agreement between them about what was to be done. The work exceeded $10 in value. And Shane didn't sublet the work or employ anyone else. It was up to him. The question really, again, it was point 3 that we looked at before. Was the work performed by James incidental to a trade or business that he regularly carried out in his own name or in a business name? Did he do painting work for others? Did he do it for himself, kind of under his own business name? He didn't advertise himself as a painter. He didn't do painting work for others. There was no evidence of any other painting jobs that he did. He was in receipt of settling payments otherwise. And he appeared to be picking up a bit of cash on the side from the pub that he frequented. So the outcome in this one is likely Shane did not have an independent trade or business. He did not himself out to the public as carrying out that trade or business. And in this instance, Shane would more than likely be considered a deemed worker. Okay, so go on.
Hold on, Shiraz, hold on. Shane was paid in cash. He wasn't paid
Yep.
on the books here, and surely he could not be a deemed worker and not be covered for the injury. I mean, the tax office doesn't know about it. How do we explain that?
It doesn't matter. What's looked at is the relationship between the respondent and the injured worker. They're looking at the nature of the relationship at the time of the injury. In this instance, the work just has to exceed $10 in value and not be something that they do regularly in their own name or in their own business name. It's pretty common that claimants are paid in cash. There's, as we all know, many reasons for doing that. It's not going to affect an injured person's entitlements to workers' comp, how they're paid. What's going to be looked at is kind of the totality of the relationship that they've got. Yeah.
All right. Well, we know what happened there to Shane, but we haven't heard what happened to. I haven't found out what happened in case study number 1, which was Terry the Tiler. So, what was the outcome there?
So Terry the Tiler, obviously he was not a worker. He was considered a contractor in that one, but there's a few things that we need to look at as a fallback position. Was he a deemed worker? So there's obviously a contract between Jack and Terry in that one. Jack provided tiling work, Terry did it. He was paid in return. He submitted invoices. They totaled 22 grand in that instance. He was an experienced tiler. He had his own ABN. He advertised his services on Facebook. It wasn't a sophisticated business, but he certainly had it. And he was performing tiling work for A1, the respondent, at the time he was injured. I think Sean and I discussed this one. What's key is Terry worked for A1 and other contractors, but the invoices he submitted to Jack are sequential, and there's no evidence that he worked for anyone else over that 9-month period. So there was, in effect, an exclusive working arrangement. If we look at the cases that Sean spoke to before, if someone basically gives away their business or stops trading regularly under their own business name, that could indicate that they were a deemed worker of the insured. But to throw a spanner in the works a little bit, he did hire labourers. There's no evidence that he had engaged a labourer on the day that he was injured, but he did do it in the past. So there's things sort of in both camps here. Sean, what do you reckon?
Yeah, I mean, it's a difficult one because you're kind of balancing, as Shiraz said, things in both camps as to whether he's a deemed worker or not. To me, what would be persuasive is that he submitted sequentially numbered invoices, and then that he didn't work for anyone else over a 9-month period. I mean, if you're talking about, there's no hard and fast rule in terms of how long you have to exclusively work for someone. But if you're talking about a 3-week period, for example, we might be having a different conversation. But 9 months is a pretty long period of time in someone's working life, and to work exclusively for one particular company, to me, would make me lean towards a deemed worker.
Yeah, it's a typical lawyer situation though, where it depends. One thing we'd probably want to look more at is him hiring labourers, how often he did that, what was the circumstances of that, how long had it been since he had not done that. That could also be really key to this one, because obviously if you're contracting other people to help you perform the work, or you've got employees, it's more suggestive of a contracting business. But again, agreed with Sean, that exclusivity there could be really key in this one. Just a bit more evidence we'd need before we'd provide a definitive point.
That call. Yeah, I was going to ask that. The fact that he would engage the odd labour from time to time would probably make him an employer with a contract.
That's right.
From a legal perspective, there's certainly lots of things that we need to consider, in each and every case, and that's why it isn't very straightforward. And what we're going to do now,
that's why it's important to get the evidence right at first instance, and going back to those earlier tables in the slide pack, some key pieces of evidence to obtain from the outset so that people can make an informed decision as to whether someone is a worker or deemed worker.
100%. And as I mentioned before, we're going to share that with everyone, but also before we finish up and go to questions in a moment, we're going to open up the chat box as well. Now just want to remind employers on the call here today that if you do engage with contractors, or you're not sure about the employment status of people you're using, then and how to actually treat them as well in your wage declarations, they're just the contact. We encourage you to contact our underwriters at icare, and the number there, and we'll share this in the email as well, is 134422. But we're also going to share a useful document known as the Wages Definition Manual, which covers off on a lot of these contractor rules that we're talking about here today, and also how to treat them and what to declare in your wage declarations as well. Because as employers, you do have an obligation to complete that online wage declaration up to 4 months from the expiry of your policy. So look, before we go to questions, I just want to quickly, we're just going to finish the formal part of the presentation and get your feedback on what you thought. We just popped up the CSAT score. Just one question. If you like the session, you got something out of it, you want to see more of these type of webinars, you'd look at a rating of a 4 or 5. If it was just so-so, you'd give it a 3. If it didn't help you at all, we'd look at a 1 or a 2. And just before we go to questions, please also pop in any feedback, any questions into the chat now as we go. But while you do that, on the screen there, we have a number of upcoming events that we're hosting as the mobile engagement team there. And they are both face-to-face and virtual. We've got the next one there, the third line down, which is the treatment of cross-border and interstate workers on the 27th of August, where Sean and Shiraz will be joining me next time. But we've also got a number of face-to-face events. Next week, we're in Nowra. A few weeks later, we're at Wollongong. And then we have some sessions in September coming up north of Sydney on the Central Coast, sort of Port Macquarie and Coffs Harbour there. And we'll give you a link to in this email that I've referred to now and how you can register to these sessions. So please pop in any feedback that you've got there, and also any questions. And there's a few questions starting to come through there. I don't know if you see that one there.
So
guys, they slip up the screen pretty quick, so you got to sort of grab them.
Yeah,
testing our tech savvy here.
Can you see them? I can read them to you if you like. Or
no, they're starting to come.
They're starting to come through.
All right.
Yep.
Yeah, so we've got a question from Tim here about the multifactorial approach. Is it a majority of the yes responses to each, or is there weight given? I think in my experience, there's certainly more weight given to some things. For example, that right of control, the exclusivity of work, that could be key, as opposed to things like the rate of pay or how someone's paid. It's not uncommon for a relationship to be structured where you both agree on a rate of pay rather than a contractor setting it. So there is generally more weight given to those ones, the right of control and things like that. But since those high court decisions, really, they'll look at the contract kind of specifically to make sure that it's not definitive. If it is, as Sean said, it'll likely be determinative. Okay.
Yeah. So to George's question, there's a big job site and there's a worker injured. How to determine the correct employer in such a case?
Yeah, that's pretty key.
That's I I suppose that's the key point that we're trying to get across today. It's really hard sometimes. So often you've got a claimant that doesn't necessarily know himself who he works for. He might have an idea, like, listen, I spoke to Greg on site. I was of the understanding I worked for him. I was wearing all Greg's company uniform, whatever that company might be called. So he'll take photos and say, well, I must have been working for Greg's company. As Shiraz just said, it's a balancing test. So it's not just as simple as, yes, you work for Greg. There's other considerations in that multifactorial test that goes into it in the absence of a written contract. So that's why I keep on stressing the importance of going back to that table, getting all the evidence you have together, submitting that to a factual investigator if one does come knocking, and then getting people like Shiraz or I, whoever it might be, that deals with these all the time, to take a look at the totality of the evidence, and we can provide an informed opinion one way or the other as to who the claimant actually works for, because it can be difficult when there's multiple employers working on one particular site.
Yeah. One thing we also didn't touch on is if you are subcontracting someone and they are uninsured and they've got an employee that themselves gets hurt, Section 20 of the Act could make you liable for that injury. So it's really important to make sure that if we are subcontracting someone, that they have their valid policies and you've done all your sort of due diligence in that respect. Because the point, obviously, of the Act is to make sure that people that are hurt doing work are covered wherever it's appropriate for that to be the case. So it's really important to make sure you do those checks and balances for anyone that's coming onto your site.
And I suppose really at the start, I gave an example of Bob, and he made his carpenters become companies, but they didn't take out policies.
Yeah.
So therefore, so Bob could have been liable for any of those injuries
that's
and the like, and the unpaid premiums under that section. But also, one of the questions here from Andy is sort of in line with this. You know, if a proprietary limited company has their own policy, does this cover the principal? I think he's referring to maybe the working director of that business. And yes, if that director is working as part of the business, normal day-to-day sort of activities, and they're getting paid, you know, to the value of $10 or more, which obviously they would be, then that person would be covered under the policy. And I'll just grab one here before you guys get another one. Peter's asking me about the any of the face-to-face sessions. Are they available online? Unfortunately, not. They're not filmed or recorded. So, you know, hopefully, Peter, wherever you're based, we'll be hosting the face-to-face sessions. We do travel around most of New South Wales over the year, but otherwise, there's recordings of webinars online. Any other questions, guys? You can see you want to grab?
Yeah, we have one from Rebecca here. As a plasterer, we hire subcontractors to do some of our work. They're all sole traders and invoice us under their own ABN. Should we have them covered on our own workers' comp policy? On the presumption that we're sort of looking at a deemed worker perspective, if they're not sort of carrying out work for other people, or they're not carrying out their own sort of business on the side and doing that regularly, definitely. I think it would be much safer to do that because you could have a deemed worker situation there. If it's sort of just to Dave's example, if they're sole traders, but they're working for you pretty much exclusively, or they're not regularly carrying on that business on the side, it would be much safer to have them covered. All right, we've got a few more.
Else there, guys? Few popping up here.
Yeah, there's a fair few coming in. It's tough to keep track.
Lisa, who's a bookkeeper. I don't know if we can answer this one here, or if we need more information. They have a client who's a medical practice, and they have employees such as nurses and admin staff. But then the doctors submit RCTI for their payment. It must be their like an invoice. So are the doctors contractors, or they be a deemed a work, or are they a worker in this example?
Yeah, that's a great question. If they're not sort of carrying on their work elsewhere, if they're exclusively working for your practice, I think there'd be a strong argument there for them to be a deemed worker, and it'd be safer to have them covered under your own policy.
Yeah, I mean, it's a really difficult question to answer without seeing any kind of contract or written engagement between the doctors and the medical practice. So we couldn't give reliable advice, I suppose, on that either way without seeing that kind of material. Yeah.
But for sort of the general deemed worker principles, you'd want to have a look at, and just, yeah, your relationship with those doctors.
Yeah.
All right.
Okay, anything else in there you can see we can grab?
What happens where a contractor is not attended to his BAS statements and therefore has no income to show as a contractor? If we're just looking at their sort of, are they a worker or a deemed worker, that's just going to be a difficulty in obtaining evidence. It's not going to necessarily affect their rights or obligations to obtain workers' comp. If we know that we're paying them, obviously the claimant has the obligation to sort of make their claim, but if we know that they're working exclusively for us or not carrying on a trade or business in their own name, and we know we paid them more than $10 worth of work, it's safer to have them covered.
Very good. And a few people here asking about the recording. Yeah, the session has been recorded. So everyone who registered, even if you missed the start or even people that didn't attend, anyone who registered for this webinar today will receive a copy, in a couple of weeks' time. We'll email that out to the registered email that we received there.
I think we've got a pretty common one here. What about if a contractor has his own insurance? Does he also need to be covered under the principal company? It's obviously great that they've got their own insurance, so they're sort of covered on the presumption that they're a sole trader. If they are bringing a claim against your policy and they can establish that they were a deemed worker, you should really have had them covered under yours instead. Conversely, if they're carrying on a business that they sort of do regularly in their own name, they might be, a tiler like Terry, and they're just doing some tiling work for you, sort of short-term work. They've got their own policy. That should be okay.
Yeah, I had a classic example that I looked at only a few weeks ago that ultimately got discontinued in the personal injury commission for obvious reasons. But essentially, this claimant got injured on the worksite. Fair enough. We don't dispute that he had a fall and injured himself. But he contended he'd worked exclusively for that particular employer. We got his financial records, so we requested a direction or a notice of production, essentially, is what you request in the Personal Injury Commission for his financial records. We got them, and he said he works for this particular company, say, through all of 2024. We got his financial records, and there was money coming in from various other people, and the description said, reimbursement for rendering, and he was a renderer. That was coming from people external to the company he worked for. The argument we obviously raised at that point was, well, he's actually undertaking his trade elsewhere in addition to this particular insured. So we're not convinced he satisfies point 3 as a deemed worker. The claimant went away. He said that he was going to put on a supplementary statement addressing that. I think he's going to have a tough time doing it, given that the transactions clearly show that he was doing rendering work elsewhere. But it'll be interesting to see how that lands when he does come back.
We've got a few people here saying about sole traders not having workers' comp policies. Yeah, absolutely. They've got their sort of separate accident cover. Yeah, that's understandable. It's more a question of, are they a deemed worker of ours? If so, we should have them covered under our policy. If they're not, then they're sort of they have to be responsible for their own insurance cover.
Yep, and I've got one here I can answer about WIC codes. Actually, it looks like they're a labour hire company, and the way we treat labour hire companies is we do apply the WIC or the industry rate as per where that worker is working. So if you've got cleaners, 10 cleaners, all those workers go into the cleaning rate. If you've got tilers, those workers go into the tiling rate. So there is separate industry rates for each worker depending on where they are working, and that's part of the administration, I suppose, for that employer in keeping those records.
We've got a question here. If a sole trader contractor generally operates as an independent contractor but doesn't hold workers' comp insurance, will their personal accident policy provide adequate cover? Obviously, we can't speak to the adequacy of that cover to protect that person in the event that they're injured, but they will have if they're genuinely an independent contractor, they've done the right thing. They don't need, if they're genuinely an independent contractor, you don't necessarily need to have them covered under your own policy if you're contracting them.
Anything else in there, guys, that you can easily answer?
They're coming in thick and fast.
They are.
We'll have some of our details there at the end as well, and obviously the slide pack will go out.
Yes. Yep.
Yeah.
And more often than not, it's difficult to answer correctly without knowing all the information, isn't it, guys? To answer in terms of how we would classify that worker without knowing all the ins and the outs of the contract,
that's right.
The employment status. So it can be difficult to respond to some of these broadly.
Yeah, that's right. When you have a chance to look through the slides, I think one of the main takeaways, particularly for deemed workers, is it does often become a balancing act, and looking at the nature of the relationship. There's a lot of things that go into that. So it's a difficult one to answer with just few snippets about the relationship.
No worries. And look, someone's here asked about the payment of the premium per month. Can they adjust that? Yep. Just contact the team and you get the details in the email, but the number's 134422, and we can make adjustments to your monthly payments if your wages are incorrect or needs to be adjusted accordingly. Yes, everyone's going to get a copy of the webinar. All right, there's quite a bit there, which we're not going to get to, guys. What we might do, unless something else you want to grab, we'll wrap it up unless there's some final questions you can see.
No, there's a lot there, but we've got our details on the final slide. I think it is, Hux.
Oh, yep. Final slide. Details in. Everyone's going to get a copy of that. There's the details there. But that's going to be emailed out to everyone as well in the coming days. So everyone will have that information. So you guys might get flooded with a bunch of emails coming in, questions and the like. But look, on that note, thanks for joining me. I know you're both very busy, Shiraz and Sean. Thanks for joining me today. It's been a very informative session on what is quite a complicated area, as we found out, as you can see from the types of questions that we're getting in here as well. So everyone will get a copy of the slide pack. Everyone's going to get some links to other resources to support your business and a copy of the video recording, the webinar recording, in a few weeks' time. Now, we do have another webinar in 4 weeks on cross-border and interstate workers and how we would treat them. So look forward to joining you then. You joining us then, I should say. Sean, Shiraz, thanks very much. I might pop back on some of those tunes and as we exit the webinar, and hopefully we can see everyone, we'll hear from everyone in about 4 weeks' time.
Thanks so much for having us.
Amazing. Thanks for having us, guys.
No worries. Thanks very much.
Thanks all.